So can I sue somebody for a second time? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Let's look at a pretty common question I get after we're done with the lawsuit and we're doing the wrap-up and doing all the paperwork, and maybe you think, wait a second, did we get all those claims taken care of? So as I said in the intro, a lot of times after your case is done, you may look back and say, wait a second, were all of the claims that I brought taken care of? Or maybe you had other things that you wanted to bring up that weren't actually part of the lawsuit. Or maybe you have an ongoing relationship with the other party and you have another claim that you want to bring against them. And the question is, can you bring a second lawsuit? You've just finished up the first one. Maybe it took 18 months, maybe it took 5 years, however long it took. With that first lawsuit done, does that mean you can't bring any more lawsuits? So the place we have to look is, how did your first lawsuit end? So, if our first lawsuit ends with a full trial in front of a jury or in front of a judge, and there's a final judgment, the first thing we have to do is look at the judgment to see what claims were adjudicated and what claims were not covered, and whether certain claims were dismissed, whether a jury said yes or no to this. It's not like criminal court where there's no double jeopardy attached to somebody who's been accused of a crime and is found innocent. But in the civil world, there are a lot of restrictions we have for civil cases, which are non-criminal, about whether or not you can actually bring that second lawsuit. And so if you've had a full trial, you need to look at the judgment and see what it says about any claims that were not in front of the jury. Maybe you waived the claims or abandoned them. You have to watch for statute of limitation problems. So if the trial or the whole case took 6 years, you may be out of luck, meaning you don't have enough time to bring another lawsuit based on old claims from 6 years ago. So it's very important, if you had that full trial, to understand what the judgment says. A second way that your case can end is what we call summary judgment. And what that means is that the judge said, there's no need for an actual trial. I've looked through the facts in this case. I've applied the law, and I find that the plaintiff wins, and that's it. So just like with a trial by a jury or trial to a judge, a summary judgment is a final decision on the merits of your case from the court that says who wins and who loses, how much money goes to who, and what all the claims are. And so you need to look at your summary judgment order or your summary judgment decision, depending how the court did it. That will tell you, once again, what happens with your claims. Some of these orders will say that all other claims are hereby denied, or they're waived, or they're abandoned, or they're dismissed. You need to understand what the wording says as to whether or not you can bring that second lawsuit. A very important distinction to understand is when there was a settlement. So many times when we settle a lawsuit, we sign what we call a settlement agreement, a release agreement, some kind of agreement between the parties that ends the lawsuit. And almost always there's going to be a release provision in there that says both parties release all claims against each other for any claims that arose from the date of the settlement going backwards. So if it was something that was already in existence when you filed the prior lawsuit, you can't then come back and sue them again because the settlement agreement says you're waiving any and all other claims. Now, not all settlement agreements will have that blanket waiver. A lot of times your settlement agreement will say it's only related to these specific claims. It's not just a general waiver or a general release. And in that case, you're able to bring claims that are not included as part of the settlement agreement. So when you have very specific settlement agreements with very specific provisions, you may be able to bring that second lawsuit as long as it wasn't covered by your settlement agreement. And then the fourth way your lawsuit can actually end is with dismissal. So let's say the judge looked through the papers and said, you know what, plaintiff, I'm dismissing your case because you haven't stated a cause of action. You failed to state a claim. Now, this means that your case was dismissed, but we're looking for some magic language after the dismissal. And the magic language is with or without prejudice. So if your claims are dismissed with prejudice, that means you cannot come back and file those claims again. The court has looked at the merits, decided you should not win this lawsuit, they have dismissed your case, and you cannot file them again. However, if it says they're dismissed without prejudice, and this can be a pretty common dismissal when we have procedural issues, maybe a service issue up front where you didn't serve the party correctly, if your case is dismissed without prejudice, that means you are able, in some circumstances, to refile the lawsuit again. Now, you have to look for statute of limitations problems. So, if it's been a long time since the injury occurred, you may be out of time and may not be able to refile the second case. But if your dismissal is without prejudice, that means the court has not barred you from doing another case on those same claims. So all of this is to say, if you're thinking of bringing a lawsuit against somebody, or you're a defendant in a lawsuit and you're bringing counterclaims against the other party, you want to make sure you understand all of your claims are being included in the lawsuit, or there's a reason they're not being included. You want to pay attention to what claims are in the lawsuit, what's being tried, what's being adjudicated, what claims are on summary judgment. Sometimes your summary judgment motion will deal with 4 claims and let another 2 go to trial. But the final disposition of your case, how the case ends, will dictate whether or not you can bring another lawsuit against that party. But you don't want to rely on that at the end. You want to make sure that whenever a lawsuit starts, when you're first involved, that you know what claims you can bring and what claims are going to be waived if the case is ended. If you have more questions, or you'd like to talk further about your lawsuit, you can go to my website, 𝙃𝙀𝙍𝙀𝙀. There's a red legal strategy session button on the front page. Click that and you'll be taken to my personal calendar. We'll set up a legal strategy session, about a 15 or 20 minute phone call to discuss your case, whether or not you can bring a second case, and what's going on. If you like this video, you can hit the like or the thumbs up button below. You can subscribe on YouTube or by going to Ayers Law TV. And remember, if you've filed a lawsuit, you've gone all the way to the end and the case is finally done, there's a good chance you can't just immediately go back and sue the other party once again.